introduce to you these two esteemed presenters who are going to be taking us through the presentation today. First of all, Janusz, just a little bit about him. You can see he's both an engineer as well as a registered attorney. He's been in the industry for a long time. He's a partner at Hahn. He really knows how to make fruit juice because in his previous life he was a senior process engineer before becoming an attorney. But since taking on the bar, he's assisted many leading companies with regards to the Foodstuffs Act as well as all the regulations and the Consumer Protection Act. And he's extensively involved, continues to be involved in GMO as well as advertising to children and the labeling regulations. Accompanying him today is Vanessa, and Vanessa is not an engineer, but she's most definitely a trademark practitioner, and she assists on an ongoing basis with clients registering and protecting trademarks, copyrights, domain name matters. She's a qualified notary, she's an accredited assessor and a mediator, and she's also part of the Hahn team, and we're so grateful to have her presenting to us today. So without any further ado, over to the two of you sitting in Pretoria. We can't wait to hear all about intellectual property. Thanks, Janusz, take it away.
Thank you very much, Linda. And thank you for everybody who joined in today so that I can give you this information. So I come across quite often in the industry that people don't really understand where intellectual property could possibly fit in their practice or the work that they do. So I'd like to first of all give you an outline of what is this field of intellectual property, and at the most basic level, you can split it into what I call human capital, which, as you can see from the little picture, is what's in your and your employees' heads. It's the experience they've gained, the practical work, etc. And then you've got what we call intellectual assets, which are the actual intellectual property that most people think of. And then you get two types of intellectual property. You get that which is registered under various laws, which we call statutory intellectual property, and you get so-called non-statutory intellectual property, which is more in terms of common law or under laws which do not require registration, such as copyright, and we'll talk about that in the course of our presentation this morning. So the intellectual assets are, in fact, what I would like to call codified knowledge. It's a way of taking the knowledge, reducing it to a form in which you can protect it. So now, while the knowledge is only in your head, it's very difficult to protect because the person can leave, walk away, and it's only in his head. Or in a worst case scenario, they get hit by the so-called proverbial bus and it's lost forever. The first type of non-statutory intellectual property we need to be aware of is know-how, and that, as I pointed out, is what sits in people's heads. It's their life experience, their practical experience, it's human capital. We then come to trade secrets. Now, trade secrets are very common, in fact, in the food industry. And in South Africa, you may be surprised to hear there's no registration process for trade secrets. We don't have a trade secrets law as such. What we do have in South Africa is common law or case law, which relates to how do trade secrets get dealt with if somebody should steal them. But more about trade secrets in a minute. We then have so-called confidential information, and obviously things are only confidential if you keep them confidential. And some confidential information can also be trade secrets. Clearly, as the name says, it's secret and it's confidential. And then finally, we have so-called common law trademarks, and Vanessa will speak a bit later about trademarks. But a common law trademark is a trademark that you've been using but never registered. And it's earned goodwill, it's developed over time. We then have statutory intellectual property. Now, statutory intellectual property is where we actually have a law, Patents Act, Designs Act, Trademark Act, Copyright Act. Now, the first three require a registration process, whereas the last one is recognized by law because there is, in fact, a law called the Copyright Act. So let's talk about how these things get protected. And very importantly, and I think you saw from the title of today's presentation and so on, was the difference between know-how and trade secrets. So know-how sits in the head of someone. And for it to be valuable or for it to be protected, it needs to be reduced to a material form. For example, write up standard operating procedures, write up manuals. How do you optimize a process? How do you get a better yield? How do you maybe get better hygiene in your facility? And for it to be protected, you need to treat it as a trade secret or as confidential information. And the best way to protect know-how is by educating employees that they in fact need to keep it secret and not discuss it with other parties. A trade secret is something that you have within your organization. It's not necessarily technical. Client list can be a trade secret. But possibly in our scenario, trade secrets are recipes, formulations, etc. And they need to be kept secret. You need to have rules of practice. How do they get kept secret? How does somebody get access to it, and how can you be sure that the person who gets access to it keeps it secret? You need to have special agreements in place in which you tell people, I will give you access to our trade secret, but you must keep it secret. And there have to be consequences if they don't keep it secret. So if somebody is supposed to keep a trade secret and they don't, you must take action against them. If you don't take action against them, you will find that you in fact don't have any rights. There are certain risks of trade secrets, and if your trade secret is technical in nature, let's say your trade secret is a recipe or a method of preserving a foodstuff, and you keep it secret, your risk is somebody else could go patent it because you've kept it secret, or it becomes public knowledge, it leaks out, and once it's leaked out, it's no longer a trade secret. Let's talk about patentability. So now, know-how and trade secrets rely on secrecy, rely on the fact that nobody knows about it, it's sitting in your offices, locked up under lock and key. A patent is in fact in some ways the opposite, because a patent is a way of registering your intellectual property, which eventually gets published and anybody can read. The thing is, although they can get access to it, it's protected by law and they should not be using it, which is opposite of a trade secret. A trade secret must never become known, otherwise anybody can use it. A patent can be granted for anything that is new, that involves an inventive step, and that is capable of being used in trade, industry, or agriculture. So a new recipe which extends the shelf life of a product, or as you've recently seen a lot in the press, Nestle claims they have a new process whereby they use the flesh of the cacao pod in order to reduce the use of sugar in chocolate. That would be new, would be inventive, would be capable of being used in industry or agriculture. That would be something that is patented. So in the foodstuffs field, you can patent a product, for example, a new ingredient such as a sweetener, a stabilizer, a preservative. You could patent a new product formulation, as I've just discussed now, for example, with the Nestle product. But you can also patent things such as new product packagings or a new form of a product which it hasn't occurred in before, which has some or other advantage over known forms. You can patent a food process for producing a foodstuff and, for example, a new preservation process. Let's say you come up with a better way than UHT. There's been a lot of talk recently, for example, of UV preservation of products. Years ago, there was high pressure pasteurization. All of these would be processes that one could patent. So if we're looking at what one can patent in the foodstuffs field, let's talk about packaging. So can you patent, for example, a new shape of a packaging? I'm going to give a further answer to this a bit later, but in principle, a new shape of packaging would only be patentable if the shape performs some sort of technical function. If it's purely aesthetic, it simply looks nicer. A honey bottle that looks like a teddy bear doesn't really serve any purpose technically except to look like a teddy bear, that you couldn't patent. But if it serves a technical purpose, then you can patent it. Possibly you've got new materials for your packaging, a new closure means which is anti-leak or self-closing, etc. And then of course maybe a new sealing means to maintain quality of the product. There are various food safety issue-related inventions which can be patented. For example, a product that changes color if it's spoiled, or indicators that the cold chain is broken. I remember years ago doing a patent for someone where on a frozen product there'd be a little window, and inside the packaging there would be a little star-shaped ice block. So if the product was thawed, the ice block would melt and the star shape would be lost, and then you knew the cold chain had been broken. Indicators that a product has been heated or reheated. If you look at some ready-to-make foodstuffs, they have a sticker, and once you microwave the food, the sticker goes black. So you know that food has now been reheated once, or heated once. And then, of course, you're going to have indicators of change in acidity, flavor, or microbial changes, and so on. All of these types of things can be taken. So let's go through a few examples. Is a new product shape patentable? Well, unless it performs a specific technical function, no. It would be a registered design and you're protecting its appearance. New packaging colors? No, probably a trademark. Vanessa might speak to that, and then or a registered design. What about a new name for a product? You know, we sometimes get inquiries. People call me and say, I'd like to patent my new logo. What they really mean is they want to register a trademark for the new product name or logo. What about new artwork for packaging? Again, no. Artwork will be protected by copyright or a trademark or a design or all of them. There's an interesting one. What about a new aroma or a new flavor? And the answer there is again that the flavor as such cannot be protected by patent, although the chemical compound or the composition, if it's new, may be actually protectable by patent. But there are some copyright and trademark developments related, for example, to aromas that will be mentioned later. So let's talk about foodstuffs and registered designs. What is a registered design? So a registered design is not a patent. A registered design deals with the appearance of a product. I think the courts have talked about as judged solely by the eye. So it's not how does it work, it's how it looks. A product shape, for example, you could get an aesthetic design registration and then that would be valid for 15 years. Packaging shape, well, if the packaging shape is only there to be aesthetic, such as the teddy bear honey bottle, then it will be 15 years. But if the packaging shape is functional, for example, you've got reinforcing ribs or a pull tab designed to fit the finger of a user, then it's a so-called functional design and the protection is 10 years. You can, of course, have both aesthetic and functional protection in some cases. Many years ago, there was a case of the Evian water bottle with the Mount Everest pattern collapse zone for collapsing the bottle prior to disposal thereof. So when you looked at an Evian bottle side on, it looked like they had a raised portion that looked like Mount Everest or Mount, it wouldn't be Everest, it would be the Mont Blanc. Mont Blanc in Switzerland. But actually, if you push the lid of the bottle towards its base, the bottle would collapse along that mountain ridge area, allowing you to dispose of a much smaller bottle. And then finally, of course, you can have a patent and a design for the same product. So it's not one or the other, sometimes it's all of them. I'm now going to hand over to Vanessa to speak about trademarks.
Thank you, Janusz. So, as Janusz previously mentioned, there are two types of trademarks. We're talking about registered or statutory trademarks and the common law trademarks. Statutory trademarks are acquired through registration with the registry. You lodge a TM1 form, they examine it, if they find it's acceptable, it gets advertised, and you generally get a registration certificate. The registration is backdated to your date of application and it lasts for 10 years from the date of application. It is renewable every 10 years for as long as you want to hang on to it. For example, Coca-Cola has been renewing its trademarks for years and years and years and will continue to do so in perpetuity, I'm sure. Common law trademarks are acquired, and Janusz once again mentioned it a little bit earlier, through use. So there's no registration, but when one uses a trademark to such an extent that you acquire a reputation and goodwill in that trademark, so everyone knows about it, and they associate that mark with you, then you acquire rights in terms of the common law. They are as strong as registered trademark rights, just sometimes a little bit more difficult to prove, because if you were to go to court, you'd have to get all the evidence of how you used it, your amounts that you sold, your amounts that you spent on advertising, etc., to prove that you had acquired a reputation. So, but they can obviously also coexist. You can have a statutory trademark that also has a reputation, so it also has the common law rights in it. Those are your two types of trademark rights. A trademark is a mark that is applied to a product to distinguish your product from the product of another. So, for example, if I'm talking about spices, I know whether I want to buy Robertson spices versus Roger spices. I know that which has a different quality. I know which one I want to. Same goes for biscuits. You could go for the spheres or the Oreos. I know exactly what I'm going to be getting from a similar type of product. So it distinguishes the product of one party from similar products of another. There are, sorry, Janusz, you just jump quickly. For purposes of registration, there are 45 classes. So when one applies for registration of a trademark, you have to classify your trademark. So if you tell me, and I'm going to use the classes of interest to food is generally 29 to about 32. But if you tell me that you want to do non-alcoholic beverages, then you register your trademark in class 32. If it's alcoholic, then you go to class 33. So for that, that's just, it was on the bottom of the slide just to mention what classes are. Mention the registration process briefly. So you start off by deciding on your trademark. I know that quite a lot of the people that design and create trademarks for you try to put a descriptive part into it, as descriptive as they can. For trademark purposes, we go quite white when we hear a descriptive trademark. It must be as distinctive, as non-descriptive as possible for protection as a trademark. We always refer to the trademark Kojak, that has absolutely no meaning, but is a very, very strong trademark. The closer the trademark is to a description of the product, the weaker that trademark is. So but obviously you start off by creating your trademark, and it can be in the form of a logo, a slogan, a word, a combination of colors. Basically anything that can distinguish your product from another product can be considered a mark. The next step, and it's in South Africa, it's optional, is to conduct a registrability search. In other words, you jump onto the online registry, the register, and you check that there's nothing else that is similar or identical. The reason I say similar or identical is because when we get to infringement of trademarks, you get protection in both. So in other words, if I were to register the trademark merit with an M, I would also have protection against use of merit with an N or merid with a D. So registrability search is always good, just to check that there's nothing else on the register that's going to cause you problems in the future. We talked a little bit about the classification, the classes. So you need to focus on trademarks in respect of the same or similar goods. You can register, two different people can hold rights in the same trademark for different goods. That is possible. So you need to focus on the exact goods and services of interest to you. Then we go for application with the registry. The registry takes about 10 months to look at your trademark, check whether it complies with the provisions of the Act, and that there's no other conflicting trademarks. They will then hopefully issue an acceptance notice. The acceptance notice is advertised in the Patent Journal, and 3 months is granted for any interested person to oppose that trademark if they feel that that trademark is infringing on any of their rights. The trademark eventually goes through, to registration. It takes 2.5 to 3 years from the application date. You get a beautiful certificate, and as I said, it lasts for 10 years and renewable every 10 years in perpetuity. There is a requirement that trademarks must be used. You have to start using them in South Africa. It's a little bit different in other countries, but in South Africa within 5 years of the registration date, not the application date. So in other words, if you have not used your trademark for a continuous period of 5 years after registration, then your trademark may be removed upon application by an interested person. The registry is not going to do this mira motu. It must also, obviously, if it's not renewed, it can also be removed from the register, and there the registrar will act on its own. You don't have to bring that to their attention. But there's also the possibility, if you can prove that someone applied for registration of a trademark with no intention to use that trademark, which is obviously a very, very high ask, but that is also possible. You can get rid of a trademark on that basis. Then moving over to copyright, which Janusz also mentioned, it's not possible to register copyright in South Africa. Copyright comes into existence automatically when skill and effort are used in the creation of work. On the screen, the list of products that can be are listed. It's artwork, music, video, textbooks, manuals, software, and databases. So those are the things that can be copyrighted. As I say, copyright comes into existence automatically. There are some other countries that you can register copyright in, and there is the Berne Convention that allows almost an international, it's most countries in the world, recognition of copyright. So sometimes if you really, really want to spend the money, you can register your copyright in another country like China or America, and that registration would then be valid inside. It would assist in proving copyright in South Africa. I mentioned that there's no possibility of registration. So although it is not registered, it is still recognized by the law, the Copyright Act. The only issue, of course, is that there is some difficulty because we can't register it. You have to prove that your rights exist. So it's always good to keep records of your drafts to show how you got to the point that you eventually got to. For example, when you're writing a novel or something, keep your drafts, so that if someone were to ask you, how did you get to the final product, you don't say, well, I dreamt it up in its final version overnight. That's always helpful to show that the rights exist, and obviously that they exist in you, which is where we go to. You have to prove that who the author or the creator is. So if it's stored on your computer, that obviously gives you the right to argue that who else would have stored their stuff on my computer. So that does help with the author creator proof. Copyright is generally owned, the first owner is the person who creates the work. There are a few sort of exceptions, but the person who writes the book, the person who makes the artwork, the person who sings a song generally. Those are the first owners of the work. Ownership of copyright can only be transmitted in writing, so it's not something that can be done just verbally. Yeah, so, and yes?
So, Vanessa, maybe you just want to mention, because I think a lot of mistakes arise from the fact that people believe if they've paid someone to design a logo or to write a jingle, that because they paid them, they own it. Can you maybe just explain that?
Yes, Janusz is correct. You don't own it. The person, as I said previously, the author, the person who creates it, owns the copyright. What you pay for is the right to use. It's basically a license that you are allowed to use that copyright. If you want ownership of a copyright, you actually have to get that designer, that whoever did it for you, to assign it in writing in a way that a judge, a third party, can identify exactly what work was created and was transferred, and ownership of which was transferred. So you can't go out and protect your artwork, whatever it was that was created for you, your logo or your design that's in an advert, and claim that you have copyright if you don't, if it is actually owned by some sort of studio that created your artwork for you. So be very careful in that instance.
Okay, so the term of copyright in South Africa is generally 50 years after the death of the author, which clearly is a very long time. I mean, you know, if somebody is 25 years old and they write a jingle for you, and they live to be 95, so they live 70 years, and then it's valid another 50 years after that, you know, your copyright could last 120 years. Compare that to a patent, which is only 20 years from the date of filing, and then it falls into the public domain. Or trademarks, which are 10 years, but of course are renewable indefinitely. So a trademark could eventually be valid a lot longer than the copyright, but you do require to do the renewal every 10 years, otherwise it falls away. Design validity is 10 or 15 years. Some of you may have noticed that on YouTube and so on, you can get old 1960s movies suddenly coming up. And the reason is the copyright in those movies is all expired, and that is why they are now in the public domain.
So also, just as far as copyright infringement goes, it is always worthwhile marking your work with a copyright symbol. On the screen are two different ways of of marking it, but as long as the idea gets across that there is copyright in the work that we're looking at. And the reason that you're wanting to advertise that there is copyright existing is that in order to claim damages in court, you have to prove that the other party knew that there was copyright existing in a work, in a type of work. So in other words, if you go to court, you can get an order to stop people from using your copyright, but a defense by the other party for a claim for damages would be, well, I will stop, or I've been ordered to stop, but I didn't know that there was copyright, so I can't be made to claim to pay damages. So very important to mark in some way that there is copyright on your work.
Sure, and I think it's the more important, because unlike patents, trademarks or designs where you get a registration and you have a certificate to prove ownership, in copyright, as there is no actual registration process, this marking is your indication that you are the owner of the copyright. So what can you not copyright? And the reason I've put this slide in, I often get phone calls where people say, I want to copyright my recipe. Why can I not prevent somebody else from using my recipe? So for example, what can you not copyright? Well, a recipe as such you cannot copyright. Take 3 eggs, 1 spoon of butter, 2 spoons of sugar, beat it and cook it for 5 minutes. You cannot get copyright in that. If, of course, it was a completely new recipe and a way of producing a new product, you could patent the product and possibly the recipe, but it wouldn't fall under copyright. Copyright is for creative works such as artworks, literary works, etc. What you do have protection for with a recipe, if you publish a recipe book, people cannot simply take a copy of your page of the recipe book and post it on their website, because that would be infringement in the publication, not an infringement of the copyright in your recipe, although the effect would actually be the same. What else you cannot copyright? You cannot copyright anything technical, for example, as how a machine works. But you can copyright, for example, technical drawings for a machine or a packaging blank, and that's quite common. There are a lot of drawings of blanks of boxes which are protected by copyright. The one problem with copyright, and maybe we didn't mention it earlier when we spoke about the infringement slide, is that in order to prove copyright, it's not copyright infringement. It's not sufficient to simply prove that the other person's item looks like yours. You have to be able to prove that they at least have access to yours and very likely copied it. It's quite possible for 2 people to have the identical same design and both are the quote-unquote original creators thereof. Then an interesting case that came up a few years ago was in Europe, the courts decided that you could copyright an aroma in a perfume. For many years, it's been recognized that you could, for example, get copyright in a jingle, such as the Intel jingle, or even the sound of a Harley-Davidson exhaust, believe it or not, was registered as a trademark. But it's only recently that the aroma or the smell of a perfume was recognized as being so specific to a product that people can identify what the product is merely by smelling it, and hence it was given protection. So that's it. Today it's a fairly short presentation, but obviously we're here to answer questions if you have anything you'd like us to address.
Thank you, Janusz. Vanessa, that was really, really interesting. And if I looked at the list of types of IP, in the food industry, you would definitely need to consider, at least trademarks and patents from that perspective, given that what we deal with on a day-to-day basis. I would assume that would be the minimum protection that a company should be looking at, Janusz.
Yes. Look, I think in most cases, if you're in the food industry, you need to have your brand and your packaging design and all of these things protected by trademark law. because it's quite frequent that as soon as you launch, somebody launches a competing product. Maybe I'll give an example of one of the suite, Manhattan suites, or one of those cases where from 1980s where people launch a competing suite brand with very similar packaging immediately after the originator launched. And
well, I can talk to you about a more recent one, which I was actually involved in, is the Spheres and the Oreos. The Oreos is obviously a very distinct biscuit with the two chocolate wheels with a white on the inside. And I was approached by someone from Spheres who asked whether you would be infringing any of the trademarks of Oreos if you were to proceed with Spheres with exactly the same, the two chocolate outsides and the white inside. And that's when you have to start looking. Obviously, Oreos and Spheres is completely different, but is there some sort of trademark on the biscuit itself, how it looks? Would a person going down the aisle in a shopping centre be confused if they saw the Spheres packaging and the Oreos packaging? So that sort of thing is very important. It's also very important, and Janusz and I were involved in a matter about 10 years ago between Dairy Bell and Parmalat, where it's important to keep your packaging updated as well. Because what had happened was that Dairy Bell was using its full blossom and Parmalat was objecting because of its use of the daisy on Everfresh milk. And Parmalat had unfortunately not kept its trademarks up to date. It had changed its packaging over time, which obviously one does to keep up with trends and so on, but not filed new trademarks for the latest packaging. And hence, as the packaging changed and so on, Dairy Bell was able to get to a much closer packaging to Parmalat's just because of the way things had evolved on the register. So that's also very important.
Absolutely, yeah, and I think it's something that you almost need to have a dedicated person responsible for, and make sure that you've got a register of when these things expire, so that you're keeping on top of it. An interesting one that I wanted to ask you regarding patents. I remember you saying, Janusz, that a patent is only a patent provided it's kept secret. So you can't talk about it, you can't manufacture the product until you actually have the patent in place. Am I correct?
Yeah, so I've just pulled this slide up there which talks about know-how and trade secrets. That's very interesting. You'll see I say for trade secrets it's got to be kept secret, and then I'll say the risk at the bottom is third-party patents. So one of the provisions of the patent law is that until you file your patent application, you have to keep your invention secret. If you disclose your invention before you file your patent application, you can't get a patent application after that. Now, typically that goes against what people's feelings would be that it should be, because you think, well, I'll launch a product, I'll see how it goes. If it's successful, I'll patent it. But it's counterintuitive, you can't do that. Once you've launched it, you can no longer protect it, and you can be sure that if it's successful, someone will copy it. In terms of the slide on the screen, you are now keeping your invention secret because it's a trade secret. But because it's a trade secret, no one else knows about it. So if someone else came up with the same recipe, they could in fact get a patent, and you wouldn't be able to stop them because you have kept your secret. And you may know this term, people talk about it, the race to the patent office. And this happened quite a lot in the early days of patenting, with Alexander Graham Bell and Edison and those people. There were programs on TV even about it, how they would literally race down to the patent office, because the first person to reach the patent office with the description of the invention would get the patent.
Yes.
And although technology has changed and nobody's racing down to the patents office, although if telecom eventually stops working and all will stop working, we may once again be racing down to the patents office. At the moment, we upload the patent application. But the first person who's got the earliest date will get the patent. So if you have an invention and you think it's going to be commercially viable, don't sit on it and wait. Because while you are sitting and waiting, somebody else could be getting ready to file theirs at the patent office, which could block you.
Yeah, absolutely. I think it's You know, everyone gets so excited about their new ideas and new inventions, but as soon as we start talking about it, there goes all the protection that we could have. I was very interested to hear you comment about who actually owns the copyright on your logo and you know, your website, for example. And I do think that these are important aspects that you need to ensure are in place when you put these kinds of agreements together, because you know, actually you don't own it, even though you've paid somebody to design it for you. So is this something that you would ensure you put into a contract with the designer or with the web, you know, the webmaster, for example?
Vanessa?
Okay. Yes, it is difficult. Obviously, at the beginning, you have to start talking about the end when the finished product is there, and at the end, when you start negotiating with someone, you already start saying, listen, I want the copyright. At the end of this, you will sign an agreement at the end, assigning ownership thereof. Unfortunately, in an assignment agreement, in a copyright ownership assignment agreement, the work has to be described to such an extent that a third party can see it. So it's easy enough with an artwork or whatever, you can just put a picture, you know, put a copy, a photo of what it is. A computer program is a little bit more difficult. So I always say, put it onto a flash drive and actually attach the flash drive to the contract so that it can be absolutely, there's no hardship in trying to explain to a judge what the product is. But then you can obviously only enter into the agreement once the product is finished. So it is a little bit of a tough one, but yes, that is how one has to go about it.
So let me quickly address the website issue, because the website issue is a very difficult one. So in a website situation, there's the domain name and there's the website design, both of which are very important. Now, when companies make mistakes, sometimes even very big companies, is they go to a hosting company and they say, we want you to register a domain for us, abcfoods.coza, and then they go to a web designer who does that, and they pay the person, they say, design a website for us, and that person goes and maybe employs graphic artists, and this beautiful website gets set up and gets hosted on abcfoods.coza. Only later to realize that abcfoods.coza in fact belongs to the hosting company. And if you go to the whois server and you say, who is abcfoods.coza, it says abcfoods.coza is the hosting company. So they in fact registered the domain in their own name, not in your name. So it's you've got to be very clear when instructing these people that they must put the domain in your name, not in their own name. That's the one part of it. But the website itself, the artwork, the content on the website, the contract when you appoint those people must be very clear from day one. Anything that you design for us on our website will be assigned to us. If you use a subcontractor, they must sign a document which says any work they do for you, they will transfer to us in writing. The difficulty is if you leave it to the end, the person says, well, there's no incentive for me to sign all these things to hand it over to you now. I've already been paid, or worse, maybe they didn't do a good job and they haven't been paid, in which case they will simply refuse to transfer the rights to you. So one does need to do all of these things up front and not try to play catch up at the end.
It sounds like
Janusz also mentioned the checking who owns that, making sure that you give instructions that it was the domain name is to be registered in your company name or in your name. Keep a copy of those instructions, because if they don't do it and you do end up heading off to dispute resolution and so on to try and sort out ownership of a domain name, you would have to prove that you gave the instruction to someone, to an internet service provider or some sort of, to do that in your name, and that they were not instructed to do it in their own name.
Yeah, I understand. It sounds a bit like, you know, when you get married, you have to make sure that you've got an antenuptial contract for if you, in the unlikely event that you get divorced. You know, you have to think about all the dirty work before you even start the fun, which I think is something that, you know, a lot of people just don't do, because you get completely carried away with the creative process and how cool this new product is going to be, or this new website is going to be. I think in terms of the just knowing what you own or knowing what someone else owns, the importance of having to actually check, and the onus is on, you know, the person who's wanting to register a trademark or wanting to register a patent. You know, is it your responsibility to then check that there's nothing else the same? How does that process work?
So for a trademark, I did mention the registrability search. Our register is open, completely open, and you can search it quite easily. So the registry does do it for you. However, I've seen some unusual results, so I would recommend that you go through a firm of intellectual property specialists. We basically have someone that will give you your trademark to them. We'll give the goods and services that you wanted to use your trademark for, and they will then delve into the register and check that there is nothing identical or similar. And in that way, exactly what you're saying, you're checking that you don't go ahead and try and apply for registration of a mark that is already there. You are also expected, because the register is a public document, you are also expected to know what is on the register. So in other words, if you start using a mark as a trademark and it infringes a mark that is already on the register, the fact that you didn't know is not a valid defense. You are still involved in infringement.
Absolutely, the ignorance doesn't act as a defense. Now, last question.
Sorry, so their copyright, of course, is different because copyright is not registered. There's no way somebody can check to see if something already exists. But of course, because copyright would only be infringed if you copied something, it is in a way very different from the patents or trademarks or designs where you can have innocent infringement. What I mean by that is you didn't knowingly copy, but nonetheless you're in the wrong. In the case of copyright, if I didn't know about your work and I didn't copy your work, but my work ends up looking exactly the same, it's not a problem.
Yes, no, I understand. Okay, then the last thing, and I think probably the most tricky one is all the stuff that is mine that I can't protect. You know, the trade secrets, Janusz. I mean, you know, that almost seems where the food industry is most exposed.
In the food industry, there's been quite a myth that it's best to keep trade secrets, and you hear all these stories. You know, Coca-Cola kept their recipe secret for 120 years, and they don't have a patent on it, and so on. Now, I get involved in a fair amount of very technical litigation to do with chemistry and so on. And I think in today, given enough time and money, you could analyze Coca-Cola so that you would know to the last atom what is in it. And you could go and make it. So I don't think it's viable anymore to rely only on a trade secret to keep things like formulation secret. Even processes for producing things. You know, I've been involved in cases where we've brought experts, where they look at the finished product, they look at the contaminants, they look at the impurities, and they work backwards to work out what was the process used to make it. So you may think you've got a trade secret. That trade secret's only going to stand until somebody with enough time and money and effort works out what your trade secret is. And then, of course, there's the dangers that an employee leaves and discloses your trade secret. You accidentally email something to someone. You meant to email it to Johnny and you emailed it to Jonathan. And now suddenly somebody has your trade secret. So trade secrets are not the ideal way, I don't think, of keeping things out of the domain and protecting intellectual property. But there are times when it is important and it does have its place.
I think, you know, at the end of the day, any employer should obviously have in place, you know, a process within your employment contract where, you know, this is addressed so that you can take steps if an employee does, you know, divulge trade secrets. I think in the food industry, which is relatively a close community, you know, I always say to people, you need to keep your nose very clean because you don't know who you'll be working for next week. You know, people do move around, and so it is important to protect and contract your trade secrets anyway, you know, by means of contract.
Maybe just by way of example, so there's a concept in law called springboarding. So if I hire an employee from you, You have an employee that's been working on developing a new recipe for a product. I then hire that employee, and lo and behold, we launch a competing product. You may be able to sue me and get an interdict to prevent me from springboarding, because I have taken unfair advantage of the fact that your ex-employee had knowledge they wouldn't otherwise have, which they gave to me, which allowed me to bypass all the development time in order to launch a product. And I've in fact been involved in a case like that, where an employee in a company who had been working on recipe development changed employers, and later the new employer launched a competing product. And this went all the way through the high courts, and they were eventually able to stop.
Yeah. Yeah, and I mean that makes sense. I think it, you know, in terms of the second company, it's just an unfair advantage, and so that makes perfect sense. Well, a lot to think about, and so for those of you that are listening that are maybe involved on the sort of food safety side, and you might be thinking, well, this is not really an area that I can get involved with. What I'm definitely going to suggest is that you share this link with the marketing people in your company, with the maintenance people in your company, because I think there's trade secrets within an organization are very widespread and are not only, you know, associated necessarily with the product or the product formulation, but I know that South Africans are very creative when it comes to, you know, new processes and new equipment which doesn't exist anywhere else in the world, and at the end of the day we should be able to protect those, you know, protect our